Car accident lawyer fees in Florida are strictly governed by the Florida Bar. What that means is that every attorney in the state of Florida is going to be using the same contract when retained by a car accident client. The contract basically provides that the attorney gets 33% of the recovery if the recovery is made without filing a lawsuit, and 40% if the lawsuit is filed in a court. It also provides that the attorney gets reimbursed for costs. What a lot of attorneys don't go over with clients is that if a lawsuit is filed, there's ways that we can recover our fees and costs if we get a favorable verdict at trial. Whenever you sit down, make sure you speak with the attorney about the percentages, what the costs would be involved, and if the attorney will take the case to trial, what they believe, or at least that you have discussions with the attorney as to what the value of the case is. But remember, all attorneys in the state of Florida are going to be using the same exact contract because we're required to do so. The other thing that's important to note about it is that all attorneys that use that contract are going to be doing it on a contingency fee basis. This simply means that if there is no recovery, you do not have to pay the attorney unless they can hand you a check. There is no way the attorney gets paid. They cannot give you a check or they cannot give you a bill for hours or for costs unless they recover money. If any attorney tries to bill you hourly or bill you for a consultation, find another law firm. It is purely contingent. We only get paid if we recover money for you. Even if we go to trial and we lose at trial, you are not responsible for the lawyer's fees or costs whatsoever. The lone exception is if you lose at trial and the other side does some procedural things, you may be on the hook for fees and costs with them. However, and I will tell you, many attorneys can do tricks and can use other methods in litigation to prevent that from happening. Any attorney, when they retain you or when you retain them, should be discussing that issue with you and how they avoid it, how they can protect you, and how the process works. Oftentimes clients are dissuaded because they hear stories of the attorney recovering 25 grand, the doctor's getting 25 grand, and the client getting $300. Many attorneys, including myself, will have a general policy that we will not take more money than our clients. Even though we're bound by the Florida Bar contract at 33% or 40%, depending on if the case is in court or not, many of us will still have a provision that we will not take less than our clients in certain circumstances, or more than our clients in certain circumstances. So again, let's say there's a $50,000 recovery and there's $30,000 in doctor bills. Generally with a $15,000 recovery, the attorney would receive a little in excess of $16,000. Well, what many attorneys would do, or some attorneys should do, and what I do, is I will make sure that I reduce my fee so that you're getting more money than me in that recovery. That's what most attorneys should do in contingency fee contracts, in my opinion. Generally in Florida, there's not an instance where there would not be a contingency fee contract for an injury case. If you're paying hourly, the only thing you're doing is incentivizing your attorney to bill more hours, just like it would be in a family law or criminal law case. The general principle behind contingency fee contracts is the attorney takes a risk along with the client. The attorney gets a large percentage, but there's also no risk and no hourly billing for the client. The justification behind this is that the client may be missing from work, or may be missing time from work, the client may be unable to work, and they may not have the money to pay the attorney an hourly fee. The insurance company, in 99.9% of all scenarios, is going to have a lot larger bank account than the client. We offset it because we have the money to fight the insurance companies. That's a general principle behind the contingency fee contract. I will tell you, if you ever hire an attorney and they bill you hourly in such a case, fire them, find another attorney. Frequently people will ask whether or not the fee agreement with the attorney makes it worth bringing a personal injury lawsuit. There's been numerous studies on this over the last 20 years. In general, the average attorney will get 7 to 15 times more of a recovery than an individual will get if they're in a car accident on their own. I'll give you an example. A few years ago, I had a client that went to the hospital and had some CT scans done and a general examination done. The bill was $13,000. The insurance company, who I will not name specifically right now, offered her $5,000 to recover or to settle her case. Well, the problem was when the bills came and when her no-fault insurance paid, she owed $8,000. Now, we were able to void that settlement with the insurance company. However, they will try to settle with you before you know the value of your case. Oftentimes, the severe aspects of these injuries don't arise for weeks or months after the accident. Many times, you'll talk to an insurance company the day or day after the accident, and the problem is that most of the symptoms don't arise, and the worst part of the symptoms arise a week later. The insurance companies try to get to you before then. An attorney, a good personal injury attorney, a good car accident attorney will know how to manage the case, when to demand a case, and when to settle a case. Never settle a case ever if you opt to do it on your own without knowing what your final injuries will be. This may be 2 or 3 years down the road. That's why these take long. These can take time sometimes. That's why you want to hire an attorney. On average, the average attorney will get you between 7 and 15 times more the recovery than you would be able to get on your own.